the defendant, so there's really nothing to suppress on that matter. And as far as the 404B and 418 motion, I got a little bit of case law, some argument, and clarify what I'd be trying to admit, the purposes I'd be admitting it for, but otherwise I would just proffer that evidence and stand on the motion as filed.
All right, let me hear from Ms. Rockwell.
Your Honor, but there is also a motion to suppress.
Yeah, I have two motions that the defense filed, a motion for exclusion of involuntary statements and confessions, and then a separate motion to suppress evidence.
Right.
So where's the state on the motion to suppress the evidence?
I'm sorry, I don't think I only.
It's on the calendar as well.
I know it's on the calendar, but I don't know if I had a.
There's two motions filed the same day by Ms. Rockwell. I have them, they're published on the calendar. Without a valid search warrant, without probable cause, search was conducted without consent, without exigent circumstances, depriving defendant of his rights to due process. There was no valid arrest made on which to base the search as incident thereto, as there was no evidence that there was any crime in progress within the constitutionally acceptable plain view of making the arrest. And
well, I can call a witness. It would be over Zoom. I can get Officer Viverito to log on and talk about those incidents if you want. I was not expecting to be working from home. It was a last minute thing. So as far as that, I can do that now. I would ask just for one continuance though on that. I don't know how I overlooked that. But if the court would like, I can call the officer right now and have her log on. Otherwise, I do have I would like to put in the certified copies of the search warrants. And I just can't do that under these conditions.
Judge, I certainly can't object to, I know what's going on over at the DA's office because of a possible exposure. And I know that the boss has directed certain prosecutors not to come into the building. So based on that, we would not object to him figuring out a way to get the certified copies to Your Honor. I could stand down for him to get in touch with Officer Viverito on regarding the motion to suppress. And we did talk, Judge, before the hearing, and he was asking me regarding the motion to suppress the statement. And we did discuss that. I didn't realize that Mr. Hiles, and we didn't discuss the motion to suppress the evidence. So I see that it might have been an oversight. So whatever the court's pleasure is, Judge.
It sounds like Mr. Hiles, first of all, there are certainly ways that you can get in a certified copy. We have the ability on Zoom to screen share. If you have the ability, if you have a certified copy, there are ways to handle that on a Zoom hearing. So let me give you a moment to see if you can reach your officer and to get the officer to log into the call. And I'll have you all report back to me, let's say in about, let's say 20 minutes. That'll be, that clock isn't anywhere near right. It's about 9:10 now, so 9:30. Why don't you all plan to report back to me? And if you want to talk offline to one another or to anyone else, you can do that. And I think, yeah, there's Ms. Rockwell still here.
Perfect. Thank you.
And you can even communicate with Miss Little, who is the administrator, can give you the ability to screen share if you don't already have it.
All righty.
All right, well, y'all check back in with me after doing those things. I'll see you about 9:30, okay?
Okay,
Thank you, Judge. Judge, may I leave the meeting?
You can
And
leave.
this just
Come-
sign back in?
Come back.
Thank you, Judge.
Yeah, Yeah,
There's
I'm
nowhere to go yet. I'm not going anywhere, Judge.
okay.
Thank
don't
you.
have to leave, but you can.
All right.
All right, are we ready on Treshawn Hadley? Who represents Mr. Hadley? There she is. That's okay. All right. She can go ahead and go back and speak to Mr. Hadley. All right, our next case is a couple minutes before, but it's State versus Darrell Jones. That's your client.
Yes,
Good morning. Good morning.
I believe we have operators as well to convey the.
Okay. Well, you're next in line after Ms. Hanson, okay? Thanks. And then who represents Rayshon Sherfield?
That's actually a private attorney on this, Collins.
Okay.
And I really don't anticipate him long.
He's on the call.
Oh, he is?
Looks like it.
Oh, okay, there he is. I
Yeah.
thought he had,
Yes, Your Honor, I am here. I was supposed to be in 2 different places at one time, so I'm juggling multiple Zoom hearings.
Okay. All right. Well, I was about to get the announcement from the state on your case. Are you ready for that?
Yes, Your Honor.
All right. For the record, this is 11 SC 98833, State versus Rayshon Sherfield for the state.
Your Honor, the state is ready. We're asking that it be revoked based on a conviction, not an arrest. So we have a recommendation to revoke 1 year and close the case. He has 1 year, 8 months, and 20 days remaining.
Your Honor, I'm so sorry. Can you repeat that?
I can, and Ms. Hodge, if you will use the microphone. Correct me if I'm wrong, but I'll just repeat what you said. Ms. Hodge said that today's revocation she's ready to go forward on, that it's based on a conviction for a new offense, and that the recommendation from the state is that he be revoked 1 year and the case be closed, that the remaining balance that she has on the case is 1 year, 8 months, and 20 days. Is that right, Ms. Hodge?
Correct.
Now, when we talk, I'm sorry, Your Honor, go ahead.
Go ahead.
When you say you revoke the remaining amount and terminate the bond, does that mean he'd be released today?
I didn't say terminate the bond. I said,
I'm sorry, terminate the probation.
I don't know how much time he has served. The recommendation is to revoke 1 year with the remaining 8 months of his 1 year, 8 month balance. The remaining 8 months will be suspended. So it sounds like the state's recommendation is that he served 1 year. I didn't hear a commuted to time served to be released today. I understood that to be credit for time served, but he has to serve a year and the remaining 8 months of the balance of probation would be suspended. Is that fair, Ms. Hodge? Ms. Hodge,
Thank you, Your Honor.
acknowledge that. So let me
And
hear
Your Honor,
from you.
my apologies. It's 1 year, 8 months, and 11 days.
All right. The probation officer just weighed in and said the actual balance is 1 year, 8 months, 11 days versus 20 days.
Yes, Your Honor, thank you. It is the defense's understanding that OCGA 171011, which I believe was newly legislated this year, should actually apply to Mr. Sherfield, and he should be given credit for time served versus the remaining amount of time he has on probation. The amount that he has served for his violations would exceed the amount he has left on probation. Therefore, we are seeking termination of the probation and release today.
So you said that 171011 he would get credit for time served. No one's contesting he'd get credit for time served, but you're indicating that based on the new legislation, the time he has served, which our calendar indicates at the time of publishing was 129 days, that would make him eligible to be released today.
Your Honor, I believe that the amount of time he spent in the other facility should also be granted as time served. And if you were to add that up along with the amount of time he has spent in Fulton County, it would exceed the amount of time on probation he has left.
Ms. Hodge, what say the state?
Your Honor, it's my understanding that while he was serving time in custody, probation was running. And so what he currently has left that is already run is the 1 year, 8 months. and 11 days. I have no objection to giving him credit for time served, but even with that credit, he still has 1 year, 8 months.
Okay, so could you hear Ms. Hodge?
No, Your Honor.
Are you using the microphone?
I am the, I'm sorry.
Okay.
Can you hear me? Ms. Hodge?
Yes, Ms. Hodge, now I can hear you.
Okay.
Try again.
I said that it's my understanding that he was, while he was serving time in Fulton County and in other jurisdictions, his probation time was still running. So that time has been deducted from his current amount of time on probation. And what is remaining after that time has been deducted from his probation time is 1 year, 8 months, and 11 days.
Your Honor, I don't believe the math is correct on that.
Well, here's the thing. The Department of Corrections determines the math on sentencing. If you have a difference of agreement, you can, after sentencing, file a motion indicating why I think it'd be maybe even a different case for determination on whether or not the Department of Corrections is correct on their calculation. But from what I'm looking at a sentence sheet dated May 18, 2011, where he was sentenced to a total of 12 years, running concurrent with another case, which I presume has closed because no one's brought up the 10 SC case. But the 12 years, it doesn't seem that it would have run at this point. I don't know that he's entitled to any kind of double credit. It would seem that just by estimation, the amount of time that the probation department says is remaining would in fact remain. Even if he was in custody the entire time, he'd still have a balance on that total of 12 years. So it sounds like the state's recommendation is what it is. It's 1 year to serve. He'd get credit for time served. Department of Corrections would calculate, that 1 year. The state's part of their recommendation is then, the balance of 8 months is suspended. It's gone. So the case is closed after the 1 year of service. So that's their recommendation. And you need to talk to your client. We can put you in a breakout room to talk to your client about it. But that's the recommendation from the state.
Yes, Your Honor. Can I speak with Mr. Sherfield?
Well, we'll have to figure out how to do that because he's here.
Oh, I got you.
Court. Ms. Little, how are we going to be able to arrange that?
Well, Your Honor, without speaking to him, I will say in the alternative, if I have incorrectly understood 17-10-11, we are seeking that the amount of time he has already served be sufficient for the violations. Further, the violations, as I see them in the petition on their face, are invalid in the sense that it states condition 1, violation of criminal law on or about 10/28, the defendant committed the offense of robbery in Atlanta. However, he was actually incarcerated at that time. Further, goes on to list a few things that he was never actually convicted for. I know there were convictions in Kentucky. I know there were convictions in Missouri. And beyond that, there does seem to be some technical violations, but we would like to at least have the petition be correct.
Can't do anything about that. What I have here is a petition to revoke, a supplemental petition, and the state's announced ready. So if you don't stipulate any of the violations, then we'll bring your client out and I'll give the state an opportunity. They've announced ready to see what, if any, of the violations they can prove. I would make a decision whether they've carried their burden, and then I'd make a decision on sentencing. So it's on for that purpose. The state's announced ready. So I think the defense options are, one, either you stipulate to the violations or not. And the second part of that is if you do stipulate to any of the violations, whether or not you want to recommend the same thing as a sentence or different things as a sentence. So it's really a two-step process. Do you see any value in talking to Ms. Hodge about the first one? Whether or not you want to stipulate to any of the violations, what the state is going forward on, it might make sense for you to talk. If she has a certified conviction in hand today, she might be able to prove her case. And you might be able to figure out what you want to do at that point. What does that sound like to you?
Yes, Your Honor, that's a good idea. I would like to do that if she's available.
It's a lot easier for me to put the two of you in telephone contact. So why don't we go ahead and let you do that? I'll step down. Ms. Hodge and you can coordinate with Ms. Little, exchange telephone numbers if you don't have it, and she can step out in the hallway and you can mute yourself, okay?
Thank you, Your Honor.
And before the breakout, Your Honor, I do want to make one correction.
Hold on, Ms. Brown. Yes, Ms. Hodge.
So, Mr. Attorney Collins, I have his phone number. I need to give him a call.
Okay, she has your phone number, Mr. Collins. She'll give you a call in just a minute. Ms. Brown, what do you want to say?
Yes, he has two probations that run really close in time, and Ms. Hodge was correct at the 1 year, 8 months, and 20 days.
So you say he has two. So is the other one the 10 SC 94740?
No, it's the Missouri probation.
Okay. So she's just going back on the record that what she'd indicated as a correction about all the time was wrong. What the prosecutor said, Ms. Hodge, is the balance. A 9-day difference, not too substantial considering what we're talking about, but a total of 1 year, 8 months, 20 days is the correct balance according to probation as well as the state. Okay?
Yes, Your Honor. Yes.
Thank you, Your Honor.
All right, mute yourself. I'm going to step down and Ms. Hodge, you can talk to Mr. Collins. I'll be back in just a minute. See how long Ms. Hanson needs. I'll say 10 minutes. Hey, I missed you. I know. How you doing? She probably stepping outside. Oh, I can't see my beautiful face on the screen. It didn't, that one didn't connect. I'm sorry. If you want to add yourself
Via your phone, you can.
Put my hands together.
Everybody in person, anyway, right? Everybody in person?
And they still have
So the world ain't gotta see you yet. No, I understand. Some will put it.
just, we probably would need this round, but
Okay.
maybe, I don't know.
It's still good, but not as much as it hurt. During, you been spoken,
I got a sprint. So I had to change my locker. I was holding this late and it really helped me last night. It kept this straight, so now this has better. That's what it is on the knee pad. For my knee, started over the night. As I get older, I don't have a problem now.
so I want something to do with something, I do it. You know, like, every day.
It gets worse where you can't sleep too long. That's like older people sleep. So they get by your side. So, you know, I have tools that I put on me to help with the knee pad last night. So that one of these don't give in a certain way. I got all kinds of problems. I need to get that so you get a shot.
Now you know. And then they don't put you back, you might hold the,
Because you know, my attic is on the third floor. of my house. So I had stairs, we had 2 sets of stairs to go up every time when we were cleaning out that house. So I did over 75 stairs in one day. That all came down and up and down. We tried to do the relay thing, you know, where we didn't have to keep going like that. Yes. So at the end of every day, I'm so had big day. But it'll be better once I do. Well, you have 2 levels, but I don't have one upstairs. But I don't have a new back. Well, you know, you have to have it. Yeah, but most of my stuff is in storage. So I'm gonna get movers this time because I was able to, I wasn't able to move my house because I had too much crap to do, too much crap to do. And everybody's, my furniture was, I didn't know. Because I bought it after we got in the house, so I was delivered in the 50 years. So I had no idea how heavy that furniture was. He said, you have to. So I told my family members, and they were listening to me like 3, 4 days. I owe them. Couldn't live without them. I never did no kind of.
Great morning. Who is the iPhone user? Great morning. Who's the iPhone user? Everybody else is here, right? That's Renee.
Oh, that's Renee.
She had you saw her, I couldn't hear it. Good morning. Who is the iPhone user? Last time. Yeah, and once you say my account on that, yeah. Is there a way for Attorney Collins to speak at this time? I'm not asking that one. Yes. There's a oh, okay. Okay, so we need to do it now because the rest of them coming out. Yes, because Johnny, okay,
4 to 5 minutes. You know, my daughter didn't know that. Of course, it's just chilling with her own stuff. That's fine. You see me, right? Yeah. Okay. I don't mean to worry something wrong, but I asked her to order, yeah, quality. Before they did the county. So. That's quickly your mom, but it was like 25 days. Right. Yeah. So where are you moving to? I'm in the apartment right now. Okay. Which is probably where are you? I don't know if you know where the Walmart is. About 74? 74 and yeah. Yeah. Right there. All there. They're building all of Walmart. Some street right on the wall. I got married to White Mountain Water Country Club. I grew up on the south side. Sort of know it. We were specific to Walmart. I know where pretty much everything in Peachtree City. I knew 20 yeah. Walmart wasn't here. Oh, yeah. What do you call? Oh, actually, okay, well, I'm a yeah. Mr. Collins? Mr. Collins? Not you, Reed. Yeah, Sean Collins? What was that right? Rashawn Sherfield. Mr. Collins? Is he gonna call Mr. Collins? Right. Can you give us a moment?
Yes.
Everybody's still talking, and then we're gonna let Mr. Collins speak with Mr. Sherfield. 5 minutes, and then. Just ask her if she's gonna call. Okay. And if she tell her we're ready. Tell her we're ready. He's gonna start there to see if there is. Yeah. To see if there is Mr. Collins, are you there? Like every time you try to have something early. I am.
How you doing?
I'm good.
I see the face. I'm very sorry.
I know who you are. I know how to see your folks. You're welcome. Mr. Collins, are you there?
Yes, I'm here.
Okay, 1 second. I have Mr. Sherfield in the courtroom. Let me put you all in the breakout room, okay? Because I think
Yes,
we're all on YouTube. So 1 second.
Okay, thank you.
Got it? Yes, thank you. Oh, man. gonna, because obviously it can't be working over these months. So what I'm gonna do is, I'm just going to stop the YouTube. No, that's not here, but what was this guy on iPhone? Who's coming on here? Yes, I can, I just did. So I'm going to. No, this is what we're gonna do. I'm gonna go on my cell phone. It's up to 8 days. Yeah. Just give me 1 second. So that's good to know that I can't do that. Or you can use mine. You want me to use mine? I'm on there, thank you. Who is it that keep, adding themselves? This is where I'm gonna keep adding themselves. No. Okay, so now I got one. I'm sorry. Okay, Mr. Powell, can you hear me? Okay, very good. Mr. Powell, can you hear me? Hold on. Wait a minute. It's real low. Say something, Mr. Powell, speak. Okay, so you're really low, my volume is all the way up. Can you check your volume on your computer? And you can hear me just fine? Okay, say something, Mr. Powell.
Yes, sir. Okay, which one, which one is gonna put me up today? Can we try to go? Is that one more time?
Okay, you good?
We got him second. We got. Going back. Here we go. We got. Yeah, tell them.
Yeah. Marissa Viverito, can you please come on to the, Zoom?
And Rhapsody,
Oh,
officer,
is that your person?
that's gonna be my witness, and I'm just gonna email you and Miss Rockwell a copy of the warrants right now,
Okay,
and then we'll be ready to rock whenever the court's ready.
so we can go back to, we can go back to, yeah, I really think we should have, yeah. You can make my phone about his Wi-Fi. I guess I can wipe it off. Yeah. So who we going? I think we're going Hadley, right? You ready on the tablet? Yeah. Mr. Hadley? Yeah. Yeah. That's like 3 days, right? Yeah.
I don't know.
Revocation,
Yeah, we have a status meeting.
Well, we're now down to order.
Hey, good morning. What's your name, sir? Mr. Hadley, good morning. Ms. Hanson, are we ready on Mr. Hadley's cases?
Yes, Your Honor, we'll deny the allegation.
Okay. So I have 3 petitions on today, 3 cases for Mr. Hadley. Position 2, 3, and 4 on the calendar, 19 SC 171921, 19 SC 166577, 19 SC 167628. Let me hear from the state.
Your Honor, the state, my witness is not present. I was supporting officer O.N. Parker, PARKER-5331. He's not present before. Not ready to proceed. I would ask for a continuance to finance.
All right, let me see your subpoena. Let Ms. Hanson see it first.
I have an electronic copy of the law.
I just need to see it somehow. I can look at something electronic if you want to pass up a device. All right, so how was this subpoena served on Officer Parker?
We served it through the APD subpoena portal warrant, and I have, we served it through the APD subpoena portal, and I can show you the confirmation where it was sent. I also copied the officer.
Have you heard it all from the officer?
I have not been on, and I also left the voicemail message.
It disconnected. I did see it, though. Go ahead. Ms. Hampton, can you hear from the defense?
Your Honor, this is the ordinary way that the state subpoenas the officers. I understand it's not the proper service. This department has not given any reason for this officer to have that case be dismissed, or the petition be dismissed for law prosecution.
Well, I think if it's a proper service of subpoena, then the prosecutor's done what the prosecutor can do, absent court compelling the officer to appear on the basis of the subpoena. So I believe the state would be entitled to a continuance with service of the subpoena, and the court's option would be then to follow up on a show cause hearing for the officer's failure to attend, which I can set. I'll give one continuance to the state on this. You need to follow up with your officer, see what the situation is. I think it's incumbent now on the state to see why the officer didn't show up, and if you need to show diligence to the court at the next hearing. If you don't have the officer here, without that, I think I'd be within my authority to dismiss for warrant of prosecution at that point, but I'll give the one continuance. You know, do what you can. We have so limited such limitations on our ability to transport people to court. So the more advanced notice that we can have as a court, you may not know, but do the best you can as far as, you know, getting in touch with the officer. If you haven't heard from them, find out a reason why you can before we get here today, because if it's a COVID exposure or some valid reason to not have the hearing go forward, we can prevent the transport. and give the space to somebody else we can use as well.
Understood, thank you.
All right, so for Mr. Hadley, we will reset his probation revocation hearing. I'll give him one time to get the officer here. I'll take up any motions at that point from defense if there's not an officer here.
That completes my business. Have you-
Yes, you can. Okay, thanks. Who's ready? Counsel, Mr. Howells, are you and Ms. Rockwell ready on Mr. Gunn's case?
Yes, Your Honor. I'm ready on Mr. Gunn's case. I got Officer Viverito logged in, and I have emailed a copy of the warrant. Ms. Rockwell had one, but I went ahead and copied her on the email. I emailed a copy of the warrant to Ms. Little, as well as Ms. Rockwell that we'd be working off of. Talked about admitting it with Ms. Rockwell, and we're good on that front. And I will attempt to screen share it during the motion if that can be made available.
Yes, okay, Ms. Rockwell, I see you're logged in, but let me make sure we have Ms. Rockwell before we bring out the client. Ms. Rockwell, if you are there, we need you to activate your video and your microphone. Otherwise, we're going to not go forward with this one. So let's hold off until we get the attorney here. Ms. Hawkins, are you ready on your case?
Your Honor, I was trying to get it to modify, obviously, the legal offer, so I'm not going with it, but you know, I imagine we're ready. You will both be ready.
And who
Good, Ms.
represents?
Rockwell.
We have Ms. Rockwell? All right, okay. Let's bring out Mr. Gunn. All right, Mr.
Can y'all hear me? I can't hear you. I can't hear you.
Mr. Howells, can you hear me?
I
Now
hear,
I can.
I can hear everybody.
Now I can. Thank you, Judge. I can hear you.
Okay, so Ms. Rockwell, Mr. Howells announced that he has his witness ready, and he's emailed you another copy of the affidavit and application for search warrant and the search warrant, and is ready to proceed. Are you ready?
I'm ready, Judge.
All right, so Mr. Howells, we are on the record in 20 SC 176866, defendant's motion to suppress evidence. Who is your witness?
Your Honor, the state would call Officer Viverito from the GBI Gang Task Force.
All right, good morning, Officer Viverito. Can you hear me?
Yes, I can. Good morning, Your Honor.
Good morning. If you will, raise your right hand. Do you swear or affirm that all the testimony you'll provide the court in today's hearing is true and correct and based on your personal knowledge?
I do, Your Honor.
You can lower your hand. Please state and spell your name, please.
Sure. My name is Marissa Viverito, and that's MARISSAVIVERITO.
Thank you. Mr. Howells, go ahead.
Yes. Officer Viverito, will you please tell the court where you're currently employed and what your role is?
I am a criminal investigator assigned to the Special Operations Division of the Department of Community Supervision. And in my role there, I'm assigned and have been sworn in over at the GBI Gang Task Force to operate as one of their task force agents.
Okay. Are you post-certified?
I am.
And how long have you been post-certified?
And my first post certifications was in 2009, and then I came back to Atlanta after a brief stint in New York back in 2017.
Okay. Have you been post-certified since 2009 up to date?
When I left, I had to get recertified when I came back.
So have you been post-certified from 2017 up until today's date?
Correct.
Okay. And how long have you been employed with the Gang Task Force?
Since November of 2019.
Okay. And do you have, did you have a chance to investigate a Michael Gunn?
I did back in June of 2020. The way the gang task force works is we can work off self-initiated cases or requests for assistance. I received a request for assistance from the Atlanta Police Department regarding a disturbing spike in gang violence that had started probably around May and was on track to continue through the summer, which it eventually did.
Okay. And how did you come in contact, or what did you find out during your investigation of Mr. Gunn?
During my investigation of Mr. Gunn and my knowledge of the gangs in Atlanta and some of the major players, I knew Mr. Gunn to have been having come up as a suspect in several gang-related incidents concerning, especially over this summer, but in the past also. But what led me to our issue today was the incidences that were occurring in the spring and summer of 2020.
Okay. And were you monitoring Mr. Gunn on social media?
I was.
Okay. And did you take out warrants for an incident that you saw on social media on July 9th, 2020?
I did. During a gang-related funeral of a fellow gang member, Mr. Gunn was present. I was monitoring the social media of another gang member, and that's where Mr. Gunn appeared.
Okay. And when you saw Mr. Gunn, what funeral was this taking place at?
So it was the funeral of Marcus Sims. He was Rolling 60s gang member over in the Parkway Boulevard area of Atlanta, over in 4th Ward near Ponce City Market. He was shot and killed in a drive-by shooting on June 30th. And he was very well liked, very well loved out there. They ended up, after, I guess, the actual funeral, they held a procession down Parkway. All of the gang members were present from several different gangs, the ones that I guess the Rolling 60s were allies with. If you watch the video, you'll see that they had the entire strip of Parkway, I don't know who's familiar with it and who's not, shut down. Cars were flooding the street. People were out of their cars. People were hanging out of their sunroofs with assault rifles and various other guns. People were walking up to cameras with guns. It had the potential to be really bad out there. So we were monitoring it all day via social media. And I'm not sure if they actually had people on the ground out there, but it was a volatile situation.
Okay. And what did you see on video of Mr. Gunn specifically that led you to take out warrants?
Mr. Gunn walks up to the camera of somebody that's filming on live. He's yelling a few things. And also what led to the warrants was you see Mr. Gunn walk up to the camera and you'll see he has a firearm in each pocket of his jeans, the right pocket, front pocket, and the left front pocket. And also you were able to see that Mr. Gunn was wearing a bulletproof vest under his shirt while possessing both of the firearms.
Okay. And at this time, were you aware of any probationary statuses of Mr. Gunn?
I knew Mr. Gunn to be on active probation and a current felon, current convicted felon out of, I believe, Fulton County. He's been previously charged with a gang count, I think in relation to a gang-related robbery. And then I also knew as a condition of his probation, he was not allowed to possess any firearms and or firearm replicas.
Okay. And did you go to execute an arrest warrant based off of what you knew in that instance?
Due to what we believe to be the violent nature of Mr. Gunn and the threat assessment, the U.S. Marshals were tasked with picking him up and doing the actual pickup. Once he was taken into custody, I responded.
I'm sorry, I don't mean to cut you off. I'm asking, did you take out warrants based on what you saw for?
I did.
Okay, at the funeral procession of Mr. Gunn. What arrest warrants did you take out?
Possession of a firearm by a convicted felon and participation in criminal street gang activity.
Okay. And did you go to execute those warrants?
I did. I was present once they were executed, yes.
Okay. And do you recall the date that the warrants were executed?
I believe it was September 3rd of 2020.
Okay. And were you present as with the U.S. Marshals Task Force as the warrant was being executed?
I was not on scene. I was nearby. And then once he was in custody, once Mr. Gunn was in custody, I responded to the scene.
Okay. And when you got to the scene, was there anything that led to you to take out additional warrants?
Yes, there was, during a protective sweep of the unit, there was a butt of a firearm sticking out from the bedroom dresser. It was a studio type apartment in a high rise. And there was also some marijuana in plain view.
Okay. Your Honor, I'm going to go ahead and try to screen share. Actually, Ms. Little, could you please give me access to screen share? Ms.
She's working on it. She's right here.
Cool.
Okay, try now, Mr. Howe.
She's saying, give it a try now, Mr. Howes.
Wonderful.
Try to share.
Well, wonderful. We'll see.
All right.
I think we have to give access to them.
I have.
You have?
Yeah,
Okay.
I got it. I'm should be pulling it up right now.
He's claiming it's now. The ball is in his court.
All right.
Success.
All right. Officer Viverito, do you, and I'm going to scroll through it very slowly, but do you recognize the warrant that I've placed in front of you?
I do. That is the warrant I obtained on the day of his arrest.
I think you could go a little faster than that.
Okay. I'm sorry. I'm going to go a little faster. Okay. And does this appear to be a full and complete copy of the warrant that you had signed on September 3rd, 2020?
Yes, it does.
And Mr. Howes, I have the same copy of it. I propose that the court reporter's here with me and with the defendant in court, and that I mark this as State's Exhibit 1 and give it to Ms. Glover. Any objection to that from either the state or defense, Mr. Howes?
No, that was about my next move. No objection.
Ms. Rockwell?
Hold on, Judge. At this point, Judge, I'm going to ask that it not be introduced until I have a chance to voir dire the witness when it's my turn. I understand that it is being referred to, at least at this point, as an exhibit.
All right, well, I'll reserve ruling on admitting it, but State's Exhibit 1 is this copy I have here. Any objection to that, Ms. Rockwell? Just did
No objection.
Okay. Go ahead, Mr. Howes.
Okay. And Officer Viverito, in reference to what we're now referring to as State's Exhibit 1, when you first made entry into the house, what was the purpose of the team making entry into the house?
It was to execute my arrest warrants for Mr. Gunn.
Okay. And after Mr. Gunn was taken into custody, were you aware if there was anybody else, or let's step back. Were there any cameras that were utilized by the team, the marshal's team, to observe Mr. Gunn before making entry?
I believe, and I'm not too familiar with the marshals or their entrance practices, but they utilize some type of camera to try and detect any threats that may be present at the location, because it was a high rise. I think we were on the 34th floor, I believe, and they weren't able to look in a window or do anything like that. They have some type of device that they use to, like I said, assess any threats that may be present in the apartment before they make entry.
Okay. And was Mr. Gunn observed at the door at that time?
It's my understanding that he was observed walking to the door with a firearm in his hand. Yes.
Okay. And so after Mr. Gunn was he eventually taken into custody?
He was. They made entry to the unit and he was taken into custody.
Okay. Was he holding the gun when he was taken into custody?
I was not present, but it was my understanding that he was not. The gun was not on his person at that time.
And was there a protective sweep done of the unit?
There was. It's a studio, like I said, a studio type unit in a high-rise condo with a, not like an official bedroom, like a half wall separating the bedroom from the living area. And they conducted a sweep through the entire unit to make sure nobody else was hiding in a closet or present anywhere else.
Okay. And was there any other firearms or contraband that were in plain view?
I don't believe so. It was just the firearm. There was a butt of a firearm sticking out from under the dresser, and there was marijuana in plain view.
And did you actually, afterwards, did you go and obtain a warrant?
I did. We froze the scene at that point, and I obtained a search warrant for the location.
Okay. And was there any specific search done of the house prior to obtaining this warrant?
No, just the walkthrough was done. Like I said, that we froze the scene at that point and held it until we received a signed search warrant.
Okay. And once you received this search warrant, did you actually go in and search the house?
We did.
Okay. And what did you recover when you searched the house?
We recovered a FN style or FN 5.7 handgun, which is the gun that was under the dresser. Also another, I believe, an AK-47 from a book bag that was on the couch. We recovered a small amount of marijuana, some stolen credit cards, a cell phone, not a small amount, but a decent amount of money. And then there was a lot of ammunition also present that we recovered. A box of ammunition, a box of rifle rounds that we recovered also.
Okay. And how long did the search take?
I want to, it was back in September, so I want to say maybe half an hour to an hour. It was a very small apartment. I believe he was subleasing from somebody, so he didn't have a lot of belongings there, but he had his belongings there, but it wasn't like he lived there for years. There was tons of stuff for us to go through. Probably about an hour to get everything out of there.
Okay. And after making the collecting the evidence, did you take out any further warrants?
I did. I took out additional warrants for the two firearms that were recovered that day.
Okay. And what county was this apartment located in?
Fulton County.
Okay. Where particularly in Fulton County?
It was 400 West Peachtree Street at the 12 Residences and Hotel. I believe it's the 12. That one is the 12 Centennial Park, I think.
Okay. And going back to the original arrest warrants that you took out, what location, when you saw Mr. Gunn at the funeral, where was he located, or what county was he located in when you observed him over social media with weapons?
He was located in Fulton County on Parkway Drive over in the old Fourth Ward neighborhood of Atlanta.
Okay. And were you familiar with that area?
I am.
And could you recognize it over social media?
I could. And then, like I said, there were also several other simultaneous video feeds and videos being posted from the same location. So we had known that was going on at that particular location at that time.
Okay. And I don't know, what were the last warrants you took out after the search of Mr. Gunn's apartment?
Possession of a firearm by a convicted felon and participation in criminal street gang activity.
Your Honor, I have no further questions at this moment.
Ross?
Good morning, Ms. Viverito.
Morning, Ms. Rockwell.
Ms. Viverito, just a couple of things regarding the social media that you were investigating. Were you looking at live social media, or were you looking at something that was posted on someone else's social media when you saw an alleged video of Mikhail Gunn?
I'm sorry, Ms. Rockwell, you froze for a second while you were speaking. I just caught the tail end of what you were saying.
Okay.
She didn't freeze on my end. She asked if you were watching a live stream on video when you saw the alleged possession of a gun by the defendant, or if it was a pre-recorded post on somebody's social media.
Oh, thank you, Your Honor. It was a actual live feed. It was, I believe, tagged with the live, however they tag it on Instagram. It was a live feed that was happening right then.
Okay. And this live feed had was posted from someone else's video or social media. Is that correct?
That is correct.
I think it said design or something.
Correct. Designer TJ.
Okay. And are you familiar with whether or not that social media feed or what have you, whatever you want to discuss, call it, whether that belonged to Mikhail Gunn or yet another person?
No, that particular social media feed belongs to a different person.
Okay. And can you tell me if, and there was a picture that I saw that was collected in the discovery, and it actually had Mr. Gunn standing there with guns, what appeared to be guns in the belt or inside of his waistband. Is that correct?
I'm not sure if it was either the waistband. I don't have the photo in front. It's either his waistband or his right front and his front left pocket. There was two guns, either, like I said, either in the waistband or in his front pockets of his jeans. I believe he was wearing jeans that day.
Okay. And those guns or those, whatever they purport to be, that your information as to possession of those items strictly comes from social media. Is that correct?
Correct. In that instance, correct.
Okay. Are you aware if those alleged items were ever recovered anywhere else?
Because Mr. Gunn is moving so quickly on the video, and it's kind of, it's hard to tell if one of those firearms was the FN that was recovered the day of the search warrant. So I can't say for sure whether it was or it was not. So there's no way to know if it was the actual gun that we recovered the day when he was arrested.
Okay. And there's really no way to know if those were even real guns, correct?
Correct. What led me to believe that they were real was the fact that in the midst of this hyper-violent gang war we had going on with murders and shootings, Mr. Gunn was in a gang territory at a gang funeral, opening himself up to gang violence. And he also thought enough to wear a bulletproof vest, which I wouldn't put on a bulletproof vest and not have my gun. So I found it reasonable to believe that those firearms were real, especially with the amount of other firearms that were present at the location and knowing that he may be a target for violence at that location.
Okay. But as far as you know, there's no, what you were going on was that quick, frantic, live social media, correct? Where he's, I guess, moving around in the street, and you don't have any other evidence that those were real guns, correct?
Correct. And I just want, it wasn't more, it wasn't like a frantic, like he ran up and was just caught him running. It was somebody was filming. He came up to the camera, flaunted his possession of the firearms to show, hey, I'm out here armed. Here we are, like in furtherance of the gang's already violent reputation, his already violent reputation as a gang member. So that led us to believe that it was reasonable that the firearms were authentic. As far as being able to see the serial number or anything like that, I was unable to.
Okay. And you're not a firearms expert, are you?
No, I am not.
Okay. And obviously, we can talk about the fact that he's on probation right now. And by the way, a condition of his probation is that he can't even have a replica of a firearm, correct?
That is correct.
Okay. So, in fact, you could have, based on that video, taken a probation warrant against him for violation of probation.
Well, in my current assignment, I don't take, he was on somebody else's caseload. He was not I was not supervising him. Where I'm at right now, we really don't handle probation warrants like that. We do criminal charges. So if he was on my caseload, yes, I would have done that. But now as investigator, and I'm not assigned a caseload or anything like that, we took out criminal charges.
Okay. So somebody could have taken out a warrant for probation violation based on just the replica, correct?
They could have. I mean, I can't officer what to do. Could have.
That was not the type of warrant that you had, a probation violation, correct?
Correct. I took out criminal arrest warrants.
Okay. And as a matter of fact, as you testified, the individuals that actually served that arrest warrant were members of a marshal's task force. Is that correct?
That is correct.
Okay. Do you know what time they got to the apartment?
Let me see if I can. I want to say around 12 or 11 that morning. Mr. Gunn was still, I believe, may have been asleep when they arrived.
Okay. And you were not present?
I was nearby, probably like down the street when they made entry, and then I responded out there as soon as they.
Okay. And so at the time that they approached the door, do you know actually how they gained entry into the apartment?
I can't speak to that. I wasn't present to witness the entry.
Okay. Do you know when the camera, the little, and I'm going to call it a little sneak and peek or a little spy camera, was actually inserted under the door to collect any type of intel or information? Do you know when that happened?
I was not present for that.
Okay. Do you know whether or not there was a search prior to you getting to the apartment?
A search of like we would do with a search warrant was not conducted. No, they did a protective sweep, just checking for other people, making sure nobody was in a closet, nobody was going to jump out of a bathroom, anything like that. And while that was being conducted, a firearm was observed on the floor, and I guess under the butt of a firearm in plain view.
Okay. And what you are testifying to is something that you heard the officers tell you as far as when they went in, how they went in, and whether or not there was a protective sweep.
Correct. I was not present. I'm not part of the marshals.
Okay.
I'm not able to make entry with them. So once they did that, we were called to the scene and we were shown what was discovered. Like I didn't see anything else disturbed or really out of place. Mr. Gunn didn't tell us, hey, they searched my place before you got here. We didn't hear any of that.
Okay. And do you know whether or not Mr. Gunn ever gave consent to search prior to the search warrant?
I didn't ask him I usually err on the side of caution, just obtain a search warrant if the conditions are there. We didn't search anything. I didn't ask him for consent. We just got a search warrant.
Okay, and do you know whether or not prior to any type of, and what you describe as a protective sweep, whether the officers there were alarmed that there may be somebody else present, or that they heard somebody else scampering away with a gun, or any other information that would have put the officers on any type of high alert that there may be some danger to those officers?
It was explained to me that when the camera was put under the door, or however they do it, or whatever kind of camera they use, like I said, I wasn't present for it. I can't speak to their tactics. Mr. Gunn had approached the door with a firearm in his hand. He then ran to what was the bedroom area of the unit and emerged, took off all his clothes naked with no firearm. So I guess I would take that, that would alarm me to the fact is somebody else.
Judge, I'm just going to object at this point to her speculating whether or not that would have alarmed her or the officer that actually
Overrule the
made
objection
entry.
and let her finish her answer. Overrule.
Okay.
As a law enforcement officer, that would be a red flag to me that maybe somebody was back there, or the gun had been passed off, or there could be additional people hiding in the unit due to his peculiar behavior. And I know, I think they would be not doing their full job if they didn't clear the unit to make it safe for anybody else to enter, or even for Mr. Gunn himself, if somebody else wanted to start shooting or something like that. So the protective sweep, it's my understanding, was done to just clear the unit of any threats. And while that was happening, the butt of the gun was seen in plain view. He did, like I said, he did emerge with a firearm, and then the firearm was not in his hand when he came to the door. So that's an issue to be concerned with.
Judge, my objection still stands.
Any additional questions?
Regarding this camera, would you admit that the camera was placed under the door, between the bottom of the door and the floor, and evidence was obtained prior to Mr. Gunn coming to the door?
I can't tell you how the camera was placed, where it was placed. I'm not on any type of entry team. I'm not up to date on their tactics.
Did the information that you received from the officers form a basis of your search warrant in front of Judge Farmer?
No, I included it to let him know that that was something that the marshal had seen. But as far as my probable cause was obtained during the protective sweep, about where the gun was in plain view. Like I said, I included it in the warrant just to be 100% transparent, but my probable cause was gained from the butt of the firearm that I observed in plain view once the marshals pointed it out to me.
Okay. You weren't there for the protective sweep, correct?
I was not. I was brought up
Okay.
because, like I said, I'm not on their entry team. I can't participate in that while they're making entry and doing what they do.
Okay. Regarding the marshal service entry into the apartment, were you aware that they had gotten a key and had actually opened the door themselves?
I can't speak to, I'm not aware of that. I wasn't, like I said, I wasn't there for an entry.
Okay.
When I arrived, Mr. Gunn was already in custody once I arrived.
Okay. Were you there when Mr. Gunn's girlfriend arrived and was actually arrested?
I was.
Okay. And were you there when she was taken away?
I might have been busy. It was a hectic day. I might have been busy doing something else, but I know she was arrested and then transported for, I believe she had an outstanding, maybe shoplifting warrant or something to that effect.
Okay. Are you aware of how, well, let me just ask you this. How long did you stay on scene?
It was a pretty long day getting a judge available. I want to say we were out there for a few hours at least.
Okay. And do you know, I'm looking at the search warrant and I think the judge signed it at about it says 15:12. That would be about 3:12 p.m.
Correct.
Is that correct? Okay. Were you one of the last officers to leave?
I probably left 2 or 3 officers out there because they were doing some additional stuff. There was a car on scene that they were searching also, because I believe that day, Ms. Rockwell, I actually had to leave and meet you.
Miss Rockwell, and I don't mean to interrupt, but it looks like we lost a lot of people on the Zoom. I'm not sure if the judge and the court are still present.
Hold on.
Judge?
Let me see.
I don't want
No.
to spin y'all's wheels.
I don't
Hey,
think
I
that.
didn't mean to interrupt, but while you guys were doing that, I saw that the host was actually transferred to Ms. Rockwell. So I don't think they're here.
Okay.
Who's helping me with that? Is that Sean?
Yes. Hey, Renee, how are you?
I can give Ms. Little a call.
It's switched
I
to 2
think
different
she's
hosts
on.
and then finally went to Renee to be the host. So I think it's just you guys.
Yeah, I think we're spinning. I don't know how much of that questioning.
Should we end and then sign back in?
No, I didn't go.
I don't think so because it's the same number. It's the same Zoom ID. So I'm going to reach out to Officer Brown, Ms. Rockwell.
Hey, Brown. Okay.
She's calling me now. 1 second.
Do you know who the host is now? Jesus. I don't even know how to add people. Hey, Reeves.
Yes.
Can we just sign out and sign back in?
No, I think it's going to be an issue at the courthouse. They have the link to sign in. I'm guessing.
They're having some internet connection issues. They're actually moving on to a probation matter, revocation. And they're actually using my phone to conduct the revocation. So I'm on speakerphone now, about to do Mr. Jones that's on the calendar. So while they work through their internet issues, you ought to know.
All right, Rita, I'm gonna call you real quick.
Call me?
No, I'm gonna call Officer Rita.
Okay.
Well, no, actually, no, I'm not. I can't call her because she's under oath. I don't know why I said that. I can't call you. So we just gotta hang tight.
2021. We're getting there though. I'm not going anywhere. I'm just going to mute and text me Reeves, if y'all come back.
All right, I will.
If I'm in do not disturb, will I receive your text? Can you text me real quick now?
You won't, I don't think you'll, I'll text you right now.
Okay, can you all hear me?
Oh, okay.
I can.
Okay. So it appears that the county internet connection is down.
Yeah.
Is yours down at the house too? Or no, you're on the
Well,
Wi-Fi.
what happened? I've got some pictures that I want to put in, and because the county internet's down, I can't access those pictures anymore because it's through the protected server that I'm pulling all this stuff up.
All right, so you can make that announcement when she comes back on. We're going to try to just continue off of my phone. And then you can make that announcement.
Okay.
Yeah, let me see. Is Renee on here?
I'm texting her right now.
Okay, Mr. Collins, can you hear me?
Yes, ma'am.
Okay, so I apologize. We're having countywide internet outage. But we're gonna attempt to resume from my cell phone. And if that doesn't work, if you're in agreement, we can go on with your case and have you like on conference call. But we're gonna try this phone out. Y'all won't be able to see anybody but the judge, but we're gonna try to make it work. And then Mr. Howes, you can make your announcement about your evidence when we come back as well, okay?
My dad always talked, usually
I'm
when he
calling
was.
Renee right now.
I'm sorry, I
Hear me?
didn't hear you wrong.
No, I was gonna say,
Who first?
no, I was just gonna say, sometimes you have to play the conditions. I think that's what we're
right.
doing.
Okay, thank you for being understanding. What were you trying to say, Mr. Howes?
I'm calling Renee right now.
Who was trying to call me? No, can't have any calls. Okay. So, can you get on from your iPad? And I started to bring my iPad today too. I think
so. I think that internet might be starting, we'll see.
Okay. He's on here. Okay.
But it looks like they're covering that up the internet. But it might be a little-
Oh, it looks like, wait a minute, let's see. I think so. Like, well, I don't know. Let me try to log, but I can't log in because it's gonna log me off the phone. Let me try to pull up something different. Nah, not at the moment, Gigi. Okay.
You didn't do your best.
So we're just we're gonna move like this. But I guess we can go ahead and bring what was hard though? From my phone. From my phone. If you see Miss Hodge out there, tell her to come on back, please, because you're about to take the bench.
All right.
Thank you.
See y'all later.
Okay, have a great weekend.
See ya. Bye. Oh, okay.
Thank you.
How you get in? I can't even get in on my phone. Without the internet.
So we got to do it on our phones, so I just went out and- I mean, if we want to know how to do it. This is what's in this one. I don't know why you're not connected to the, county Wi-Fi or anything online.
No, nope. No.
Make sure it's still.
I guess I can join it, but I don't know the meeting ID and all that.
Let me see if I can- It is. Ready? 961. 2474.
Okay, okay.
Okay, you gotta put your audio and your.
All right.
Oh, your audio should be at the top there. Yeah, that's the audio, yeah. And then.
Oh, there it is.
But you gotta vote, that little, because that's not, it's, but it was done.
Oh, okay, all right.
Yeah, the X up there, that little sticker, at the top there, the X.
Yeah.
Yes, let me do it.
But I- Well, you're not gonna be able to get it on there. No, I can't, I have to do the hotspot and it won't. Do it. But let me go get my little. Well, listen, I'm so glad you did my mic, because you know I'm saying. I have, position 6, but you know, they had to stop during position 1. Yeah. I'm in the restroom. The baby in the streets, are dry. I mean, if you want to.
love ground level. Oh my God. I sure do. Are you serious? Oh, my. Oh, yeah, we're right on the table. Yes.
All right, let's try this. I believe we have folks up on a couple of different connections with phones on the Zoom video conference. How about Mr. Collins? Are you there on Mr. Sherfield's matter? There he is.
Yes, Your Honor.
So I can be closer and forward.
Yeah, I just need you to be able to be heard, just to other people be able to hear you. Do you not have access? Yeah, why don't you come up here, a safe distance of 6 feet away from me, right about there, and just speak up nice and loud.
Attorney Collins, can you hear me?
Yes, I can.
Okay, go ahead. We have your client, Mr. Sherfield's in court. You're Mr. Sherfield, right? Good morning. I'm fine. Sorry for the delays. We've had a few other cases and some technical issues. We now have your counsel on video conference. Mr. Collins, will you speak up and say hello to your client?
Good morning, Mr. Sherfield.
Good morning, sir.
All right, Ms. Hodge, let me hear from the state. Where are we?
Your Honor, the state is ready to proceed. We have a proof of conviction of a Kentucky conviction. It's actually on my laptop, which I cannot access yet right now, but Attorney Collins does have a copy of that. That is the portion of the petition that we are proceeding on. The state is recommending that 1 year, to revoke 1 year and then close the case. There's 1 year, 8 months, and 20 days remaining on probation. And I believe we discussed stipulating to the violation and argument on the punishment.
Okay, Mr. Collins, and correct me if I'm wrong, if I misinterpret anything, Ms. Hodge, that the state, while the warrant indicates the number of alleged violations, the state is going forward on one, of which there is a certified conviction that the state has for a Kentucky violation. What is that charge?
It is, it's escaping me. Yes, thank you. Possession of a forged instrument. And Your Honor, we don't actually have a certified copy, but we do have a letter from the Department of Correction. Yes, with proof of conviction and custody dates and sentence.
Okay. So state's going forward, sounds like on that one conviction and waiving on the others, not they don't have proof of or not proceeding on the other alleged violations, and is recommending a sentence of revoking 1 year and then closing out the balance. What say the defense, Mr. Collins?
Your Honor, if the court will indulge me for just a second, what the technical difficulties gave me an opportunity to do is research this 17-10-11 new.
Okay, well, let's start one at a time because it's a two-part process. One, is he going to challenge the violation?
No, Your Honor.
And if he's not going to challenge the violation, then I think we just discuss sentencing, and that's where that statute, as I understand your argument, would come into play. Do you agree on that?
Yes, Your Honor.
Okay, so you don't contest the one violation, is that correct?
No, Your Honor. We stipulate to that conviction.
All right, so I will hear your argument then on the sentence then and your reference to that statute.
Yes, Your Honor, thank you. So 171011 was newly written by House Bill 984, which added very, very important terms. Pertinent terms to this case would be Section 3A, which added upon conviction for an offense, a person shall be given full credit for each day spent in confinement in any penal institution or facility. That was not in the original statute. And further, it goes on to add subsection D, which states this code section shall apply to sentences for all crimes, whether classified as violations, misdemeanors, or felonies, and to all courts having criminal jurisdiction located within the boundaries of this state. Now, I will submit to the court that this is brand new. That is simply my interpretation that it would apply to this particular case. Mr. Sherfield should be given credit for the time he served there against the remaining amount of time he has on probation in Fulton County. I will also further submit that it's so new, there's no appellate cases to help with the interpretation. If the court is inclined not to agree with that interpretation, we, of course, have stipulated to the conviction, but we would ask for credit for time served since the incarceration in Fulton County, which today marks 143 days. We feel that is sufficient for the violation. Further, Mr. Sherfield has children at home, a spouse at home. He has not seen them in quite some time. We do feel as though he has paid his debt for his actions. And in fact, today is one of his children's 10th birthday. Upon my representation of Mr. Sherfield, he actually pointed to this day saying, is there any chance I can get home by the 19th, March 19th? Of course, I said there's no guarantees, but by the grace of God in Miss Little, we actually have a court hearing today on the 19th. Further, I would also like to remind the court that Mr. Sherfield took it upon himself to write a letter to this honorable court and this honorable judge, showing a great deal of remorse, acceptance of his behavior, and asking for another chance. So if the court is uninclined to agree with the interpretation of the new statute, we simply ask the court to give him credit for time served, reinstate the balance of his probation, and release him.
All right, anything further from the state now that Mr. Collins has elaborated on his statutory argument?
No, Your Honor.
Okay. All right, the court finds that the parties agree on the one violation. So based on the one violation, the court finds that there is a violation of the law as to the one possession of a forged instrument conviction in Kentucky. And the court is revoking 1 year and giving the defendant credit for the time served in custody. I'm not commuting it to time served. Giving him credit. I don't think that statutory interpretation argued by Mr. Collins amounts to a release date of today based on the 143 days in Fulton County. However, it's up to the Department of Corrections to determine the actual credit days. I am simply not commuting it to time served in my sentence. It's going to be 1 year revoked, and I'm not going to reinstate the balance. I'm going to, as the state recommended, just close it out after the 1 year is served. And should defense counsel think that that is incorrect, I think you have other means to motion the court or petition the court for recalculation. But that's my sentence for today. Anything else for the state?
No, Your Honor.
For defense, Mr. Collins?
No, Your Honor, thank you.
All right, Mr. Sherfield, good luck to you. You're excused. Oh, give me just 1 minute. Ms. Brown, you need to give him reporting. There's no reporting instructions now. So you have to serve the remaining 1 year. You get credit for time you have served of that 1 year. After that 1 year, you don't have probation on this case. I'm suspending the probated balance after the service of 1 year. I'm basing what I'm saying based on what the attorneys are telling me about the number of time that you have left, whatever, you can calculate it. You have to serve a total of 1 year total. So whatever time you serve, you get credit towards that year, and you have to serve the balance of it. If you have any questions, you can talk to your attorney, Mr. Collins, okay? All right, you're excused.
Thank you, Your Honor. May I be excused?
Yes, sir. Thank you. Sorry for the problem with the technology today.
Okay, you got to play the
Thanks for your
conditions.
patience.
Thank you.
That's right. Thanks. Bye-bye.
Your Honor, that concludes my business.
Yes, you may. Thank you. Thanks. So our internet's still down otherwise. All right. Let's see. I see we have Mr. Howes. Ms. Rockwell, are you there?
Yes, Your Honor.
All right. Are you all ready to proceed with the remainder of Mr. Gunn's hearing?
Yes, Your Honor.
I can. I had the issue I'm having now is that I had two pictures that I was going to introduce, and I had them pulled up, but they are on my server that is directly connected to the courthouse, and I was accessing it remotely. And because of the internet access, I cannot access those photos as well.
All right. He can have a seat at the council table. So what do you say? What do you think about that, Ms. Rockwell? Are you aware of what these pictures are?
I'm trying to see if I can find it in my, can you give me the page, please, Mr. Hiles? If I can find it in my paper discovery, it is a picture.
It would be on the disc that we provided you. It was just a picture of where the marijuana and where the firearm sticking out in plain view is.
I aware of what those pictures would show.
So with this complication of Mr. Hiles, his access to that is on the server that he can't gain access to. We have dialed into Zoom by handheld devices here in the courtroom, but he is not able to, without access to that network, get those copies. You don't have other copies by email or anywhere else, Mr. Hiles?
No, Your Honor, I was not even planning on being home, but for the exposure that we were told we can't come in. And
no, I understand that. Just thought I'd ask.
No.
So are we going to need to reset the hearing to go through those pictures at least? Or is there any dispute about the pictures such that the record can be supplemented by submission of those pictures after the hearing? Perhaps Mr. Hiles could send it to Ms. Rockwell to confirm that we're talking about the same ones and add it to the record after that. What do you say, Ms. Rockwell? What do you think?
Judge, that would be fine as far as those pictures. I understand. I know exactly what he's talking about. And I feel like if he could put his hands on those pictures, he would submit those as an exhibit.
Okay.
So
any
I'll still
other
have
evidentiary? I'm sorry, go ahead.
I still have my objection standing regarding the voir dire of not only the search warrant, but also of those attached pictures. But I do agree, Judge, that there is a picture of items that he would be able to submit.
Okay. Are there any other evidentiary issues, Mr. Hiles?
I believe that's all I got. I can work around. I guess I'm not sure what the objection is. If I would.
Well, we can deal with that, but as far as any reason we could continue on the video conference, we're currently doing it.
Let's just roll with it. I guess we got to deal the cards we're dealt these day and age.
Yes. Okay. So when last we met.
And Judge, where did you fall off?
Because
that's what I
for a long time.
Well, that's interesting. You have no idea, do you? Yeah, we completely lost contact. The whole network here went down. Let me look back at my notes. I've done a lot since we have. I had that Miss Rockwell had the officer on cross. We had gotten through the objected to testimony by Ms. Rockwell that I overruled and allowed the officer to testify regarding her beliefs regarding the reasonableness of the sweep search. There were questions, and there was more questioning after that. I had that you were questioning about the camera that was used by the U.S. Marshals prior to the entry. What happened after that? I'll tell you if I heard it.
So let me tell you what I think happened. Sean Collins kind of interrupted us and said, Ms. Rockwell, you're the host now. And Reeves said, we don't have the judge, we don't have Rhapsody, and we don't have.
Okay, that's fine. The important part is, when was that? And in the questioning.
Reeves.
I mean, she was still on cross, and
let me
I know the last question.
Let me ask the court reporter. Hold on, she's right here. You know what's the last question you have? She's gonna look up what we were able to record. That'll tell us the answer.
Can you say that again?
Yes, I have the last question from Ms. Rockwell.
I'm sorry, let me go back. I can't write what you're talking, so I'll just.
Question regarding this camera. The camera was placed, ? Answer. The door between the bottom of the door and the floor, and evidence was obtained prior to Mr. Gunn, and then you froze. So that's where we left off.
I'll start the question over. Ms. Viverito, are you still with us? Officer Viverito?
I am.
Okay. Is it fair to say that you were not there to see anything or hear anything prior to being contacted by the U.S. Marshals to come on over because Mr. Gunn was in custody?
Correct. Once I arrived, he was already in custody.
Okay. Do you know how the apartment was secured when you left or when anyone left?
I was not the last person to leave. Like I said, I believe you had been waiting at headquarters for me for quite a while. So I was trying to get down to meet with you. So I left the apartment in the care of 2 other investigators. And
Okay.
from my understanding, they may have met with management. I know Mr. Gunn was living there under an alias on a sublease. There was a lot going on. But I believe it was secure at some point.
Okay. Do you know whether or not there was a key with a fob supplied to the team to get up and go into the apartment?
That, like I said, I wasn't there for the entry or any.
Okay. All right. Your warrant that was submitted to to Judge Farmer regarding the residence, it was a no-knock warrant. Is that correct?
I did not ask for a no-knock warrant, no.
I mean, I'm sorry, it was not a no-knock warrant. The team did not have authority to enter without knocking. Is that correct?
Are you, I'm confused. Are you talking about my arrest warrants?
I'm talking about the search warrant that was given.
They did not make entry to the apartment with a search warrant. That's where I'm getting confused.
Okay. And
they had done their job with their fugitives. Like I said, I'm a gang person, not a fugitive person. They did their job to track him to the location. It's my understanding that they learned from the staff at the location that it was the first party address for Mr. Gunn. And once it was determined that he was believed to be inside from whatever they used to determine if the person is inside or not, it may have been the camera, it may have been another method I'm not familiar with.
okay.
When they made entry, because it was a first party address for Mr. Gunn.
All right. And regarding the entire scenario, the search warrant that you got was based on evidence that was procured, seen, allegedly in plain view during what you call a protective sweep.
Correct. The protective sweep, once I arrived, the items in question were pointed out to me by the marshals on scene that were holding or freezing the location and freezing the scene.
Okay. That's all I have, Judge.
Redirect, Mr. Howes.
Yeah, briefly. You did actually have pictures taken of those items that were in plain sight, correct?
Correct.
Okay. And based off the circumstances where we can't show them here, I will move to admit those on a email where I will include Ms. Rockwell, the court, and Officer Viverito, so everybody can be on the same page about that. And just to be clear, before you obtained this search warrant, were you pointed out to where all those items were that were in plain sight?
I was.
And so you were able to lay your eyes on it?
Correct.
Okay. Your Honor, I have no further questions.
Anything further on that? Recross, Ms.
Just regarding these photographs, you said that you had the photographs taken, or you yourself took them?
Either myself or Investigator Belknap took them. We both had cameras on scene. We will divide tasks up amongst the team, but I think we may have both taken photos just to cover all the bases.
Okay. How is it that you took your photographs? Was it with your cell phone, or did you have an evidence camera?
No, I have an evidence camera issued to me from the GBI.
Okay. Were there body cams that could help us with any of this? Or
I was not wearing a body cam. I can't speak to if anybody else was. I'm not really, like I said, it was back in September. I'm not 100% sure.
Okay. That's all I have, Judge.
All right, Ms. Rockwell, let me hear your objection to the entry of State's Exhibit number 1.
Your Honor, when the reason I objected and I wanted to voir dire, has the state concluded its evidence?
Yes.
They have moved to admit, and you've objected, and I'm about to rule. So let me hear the basis of your objection, regardless of whether or not they have additional witnesses.
Judge, my concern with this search warrant is that the witness that's presented to the court today is a witness that comes on the scene and is testifying to something that another officer saw, another officer suspected, a protective sweep, and how officers may have felt during the entry, whether or not there was any concern or danger, whether or not they needed to go and make sure there was not anybody else there that would have authorized a protective sweep. The fact that Officer Viverito was not first on the scene, what she is testifying to, and what she testified to Judge Kevin Farmer is information that was told to her.
So I'm understanding that to be a hearsay objection.
And I do understand that in a motion hearing, hearsay is used just to explain course of conduct, Judge, but it should not be used by this court for substantive nature. The officer that should be testifying at this point to enter that or to tell the court about who, what, when, where everything was, whether or not a protective sweep was needed, should have been the officers that first got there. I know we don't see these marshals very often. It's the best gig in town because you don't ever have to go to court. But when there's something as important as entering a residence with a spy camera, entering a residence for an alleged protective sweep, the court cannot just assume that that is satisfied when Officer Viverito, who was not there, is applying for a warrant. So therefore, I would object to the introduction to that warrant.
All right, thank you. Any response by the state?
I have two responses. One, Officer Viverito did testify to that she was directly pointed out and saw where the items were in plain sight. And secondly, I don't think that's a valid objection based on OCGA 24-1-2, which says the determination of the admission of evidence, or the rules of evidence shall not apply to the determination of the admission of evidence when the issue is to be determined by OCGA 24-1-104. In quoting that particular statute, to read section A verbatim, it says preliminary questions concerning the qualifications of a person to be a witness, the existence of a privilege, or, and this is the important part, the admissibility of evidence shall be determined by this court subjects to the provisions of subsection B of this code section. But in making this determination, the court shall not be bound by the rules of evidence except those with respect to privilege. Preliminary questions shall be resolved by a preponderance of the evidence standard. So I would just argue that this is dealing with the preliminary question as to the admission of evidence pre-trial. Certainly, if we were at trial and if this would make it that far, all of those witnesses would be present to prove our case completely and fully, and make sure that the witness has his right to confrontation. So that would be my response to those objections.
All right. I'm going to overrule the objection. State's exhibit number 1 is admitted, and I will consider it. Let me hear, is there any additional witness for the state?
Not for this hearing, Your Honor, no.
Any witness for defense?
Your Honor, I am considering calling Mr. Gunn. I think I do need to explain to him, or the court at least needs to explain to him, his right not to testify.
Well, I think it's best that you talk to him first. Perhaps we can accomplish that. I'm not sure how. At this point, we have him here in court. We could perhaps get him a phone since you're not here to talk to him. What say you?
He is not on a Zoom or anything, correct? Because I could
He's
get
here in court. He's
Okay.
here in court with me, so he's hearing us. He can't see your. We don't have it up on the big screen because of loss of connection, but he can hear you just like the court reporter can.
Judge, let me just, I know that his mother is there. If she could provide a cell phone to him so I could explain to him what the court will also explain regarding the, his right not to testify.
Is the mom here? Do you have a cell phone? Okay. Deputy, I would like for him to be able to use the cell phone under these circumstances to help the defense talk to the defendant. So let me step down and do you have the telephone number of Miss Rockwell, Mom? You do? Okay. If you'll call Miss Rockwell and allow Mr. Gunn to talk to her, I'll step down.
Thank you, Judge.
I'm back.
Can y'all mute the proceedings in the courtroom so we can't hear?
Yes, just hold on 1 second.
Thanks.
Renee, are you on the cell phone call with them?
Say it again.
They're on the phone trying to reach
Oh,
you.
let me leave then.
Right, I'm back. Mr. Gunn's back. We have Mr. Howells. I see Ms. Rockwell's name still, but I don't see your video. Are you on, Ms. Rockwell?
Whoop. She just disappeared.
Par for the course today, par for the course. Patience is the name of the game these days. I'm sure reasonably confident that she's trying to log back in.
I am too. All right, there we go. Ms. Rockwell?
We saw you for a minute and we see your log back in, but we can't see you now.
Judge, I'm sorry. I just always want to change my name to my, from my driver's license to my lawyer name, just so the record will be,
Clear.
will be complete. Judge,
Yes.
I've had a chance to talk with him about his right to remain silent. I know the court's going to explain that same thing to him. He does want to testify. I would ask that the testimony be reserved to the issues in this motion to suppress.
You unload that, or do you have a charger? All right, Mr. Gunn, so you had a chance to talk with Ms. Rockwell regarding whether or not you want to testify. Is that correct? You understand that it's your choice on whether to testify, not that of your attorney. You understand that? Do you understand you have a right to remain silent and your silence can't be held against you? Do you understand that? Do you understand you also have a right to testify? And if you want to testify, your attorney, no one can prevent you. I can't prevent you. No one can prevent you from testifying. Do you understand that? Do you understand if you testify that not only will Ms. Rockwell be able to ask questions of you, but the prosecutor will be able to ask you questions in cross-examination as well? Do you understand that? What is your decision? Do you wish to testify? Do you wish to remain silent? All right. He has chosen the option of testifying. So if you will, walk him up to the witness stand here to my left. You know what? We do? Okay. You're good. Yeah. Oh.
You swear or affirm to testimony the first last name for the record.
All right, Mr. Gunn, you're a little soft spoken, so it's important that everybody be able to hear you. And since we're doing this somewhat remotely and somewhat in person, it's really important that your attorney hear you, and she's remotely. So you got to speak up nice and loud. She needs to hear you, okay? Ms. Rockwell, simply raise your hand if you can't hear him at any point, and I will interject, okay? All right, so Ms. Rockwell, you have your client on direct.
Mr. Gunn, please state your full name for the record. Okay, I'm going to call your attention to September the 3rd, 2020, and to an incident that occurred at 400 West Peachtree Street, Unit 3415, Atlanta, Georgia. Sir, were you present at that unit when the unit was searched by the Marshal team?
was outside.
Okay. Let me get a little bit prior to that. Were you inside of the unit asleep when the marshals came to the door?
Yes, ma'am.
Okay. Was that a residence that you had spent the night that night and were awakened the next morning?
Yes, ma'am.
Okay. Did you hear the marshals knocking on the door?
Yes, ma'am.
Did you, by any chance, see any kind of little secret camera that was placed under the door?
No, ma'am.
It is, I'm sorry, I'm hearing a little bit of noise. I'm sorry, Judge. Can the court still hear me?
Yeah, I'm not hearing it, but
Okay.
I can hear you okay.
All right. Mr. Gunn, when the marshals knocked on the door, how did they gain entry into the apartment?
They had used a key that came downstairs.
Okay. Did you have a chance to see the key?
I seen the, I don't know if he was a detective or something, but he had it.
Okay. Have you been present during the entire hearing this morning?
Have you
Okay.
been present in court during this hearing, the entire hearing this morning?
Yes, ma'am.
Okay. Did you see the officer that was testifying in this hearing?
Did I see
And Judge,
him?
okay.
What were you going to ask, Ms. Rockwell?
And I was going to ask the court, and just for the purposes of the rule of sequestration, I would ask if the court could have Ms. Viverito in perhaps a waiting room or somewhere else.
Yeah.
Well, the rule of sequestration has been invoked. Do you need your officer to remain for any reason, Mr. Howes, or can we just completely excuse her?
Can we let her go? And I can, if I need to recall her, Officer Viverito, can I just reach out?
Yeah, that's fine.
Okay, so if we need to recall her, I can reach out and have her log back on. Is that all right?
Yes, if you'll just stand by and wait to hear from Mr. Howes, Officer Viverito. Otherwise, if you'll just log out, okay?
Sure. Thank you.
Yes.
And Judge, just with all candor, in the event that I call Miss Jade Abercrombie, I would ask the court to ask her if she would step out of the courtroom in the
Ms.
event.
Abercrombie, if you'll step out outside the courtroom, okay, we'll let you know as soon as you can come back in, okay? She's stepping out now.
Okay, thank you, Judge. And she's not aware of any of the facts of this search.
Okay.
Mr. Gunn,
Yes, ma'am.
you testified that that you saw the officers open the door with a key.
Yes, ma'am.
How or where situated in the apartment were you when the officers came in?
I was standing like balcony, so it's not really like.
Okay. And were you directed by the officers to either face them or face away?
Yes, it told me to turn around and walk back upstairs.
Did you have your hands up or down?
Your Honor,
Okay.
I'm having a lot of trouble hearing his answers to the questions.
All right, he said he had his hands up, and so I'll caution the witness to speak up nice and loud. Mr. Howes, if either of you, Ms. Rockwell, Mr. Howes, raise your hand if you can't hear any answer.
Okay. So, Mr. Gunn, just so I can understand, you had you were faced with your back towards the officer and your hands up?
Your Honor, I'm
Yes,
gonna
ma'am.
check the leading.
Okay, well,
Well, she was just clarifying what he had
Okay,
just testified to.
I didn't
so.
even hear. All right.
okay, I don't want to put words in your mouth. Were you facing in any direction?
I have my back towards them, which is towards the door. My back.
Okay. Okay. Did the officers direct you to put your hands up, or did you just put them up?
Just put it on.
Okay. Did the officers direct you to move in any direction?
Yes, they told me to come towards them.
Okay. Were you walking with your face towards them, or were you walking with your back towards them?
With my back towards them.
Okay. Where did you walk to?
Towards the front door.
Okay. And is that the only door to the apartment?
Except for the balcony.
Okay. And you're 34 floors up, correct?
Yes, ma'am.
Was there any officer on the balcony that was directing you in for any movement?
No, ma'am.
At this point?
No, ma'am.
How far did you go towards these officers?
Okay. You didn't say, what's the question again?
She said, how far did you go towards the officers? Are you asking him how close he got to the officers?
Yes. How
close
close?
did you get? When you were backing up to the officers, how close did you get to the officers?
2 feet away.
Okay. And was that at any particular spot in the apartment?
It was at the front door.
Okay. When you got about 2 feet away, what then happened?
They grabbed me apartment.
I didn't hear the second thing he said, Judge. I heard they
I
grabbed
believe he
you.
said they grabbed me and took me out of the apartment and surrounded me, slammed me, he said.
Oh, okay. Where did they slam you?
Out in the hallway.
In the hallway?
Yes, ma'am.
Okay. And did you have did you have handcuffs placed on you?
Yes, ma'am.
Okay. At that point, did anybody ask you if they could go into the apartment and search?
No, ma'am.
Was there anybody else in the apartment?
No, ma'am.
Was there anybody else? Was there anybody else that had scuffled around the apartment and jumped out on the balcony to go to any other spot?
No, ma'am.
I believe you testified that you saw the officer that testified in court today.
Yes, ma'am.
Was she part of the first wave of officers that came through?
No, ma'am.
Okay. You heard her testify she came later.
Yes, ma'am.
Okay. Were you ever presented with a search warrant prior to the officers going into the apartment?
No, ma'am.
After you were handcuffed, surrounded, I guess, on the floor of the hallway,
Yes, ma'am.
did officers ever go into the apartment?
Yes, ma'am.
And what were they doing when they went into the apartment?
I really couldn't see that they moved in. I heard them say something like, is there any more idiots in here or something like that?
Okay. Did you see whether or not, did you see how many officers went into the apartment?
Really like 7, 8 of them.
Okay. And what were they doing when they were in the apartment?
I really couldn't see from the door. But they brought me back in probably like 15 minutes later. They were just looking around. I had like a dummy person sitting down. They looked at him.
Can you repeat that, please?
They had like a dummy
So
person?
I had like a dummy person that I had in my video, but I had them sitting like in the living room, and they was looking through what this is right here, because it looked like he got blood on it. And like, what this is right here? I'm like, this is a dummy bag.
Okay. But prior to Officer Viverito getting to the apartment, were there any officers searching the apartment?
Yeah, they was walking around.
Okay. And you heard Officer Viverito talking about the fact that there were, that they had located, or that a gun was seen or located in the apartment.
Yes, ma'am.
Do you know whether or not the officers were searching the apartment prior to a search warrant being obtained?
But before she got there, they was already walking around just looking at everything. Some of them looked in the refrigerator, some of them walked on the balcony and was like, this is a nice view up there. What you paying money here? That's like questions.
Judge, could you just tell me so I make sure I heard what he said?
You will repeat what you said into the microphone?
Yes, ma'am. I said, some of the officers was walking around, some of them looked in the refrigerator, some of them walked on the balcony and was like, this is a nice view up there. What you paying money here? And just asking me questions about the apartment.
How long was it before, or let me ask you this. Do you know exactly what time the first entry was made by the first group of officers?
I want to say like 10 o'clock.
In the morning?
Yes, ma'am.
Okay. And if I told you that the search warrant was
Objection, Your Honor,
signed,
meeting.
well, I think the search warrant is
That's
being
fine.
introduced.
You're right. You're right.
Okay.
Go ahead, Ms. Rockwell.
And if I told you that the search warrant says that it was signed around 3 p.m., is that about right? Hours later?
What are you asking him to testify to?
I'm asking him, in his mind, was it hours later that the search warrant was presented, or at least he was notified that there was now a search warrant?
And then it was notified that it was searching.
I just had a little trouble. Let me ask you this. Was there a search to your apartment prior to the search warrant being issued? If the search warrant was issued at 3 p.m.?
Well, let me make sure you heard his last answer. I believe he said he didn't know, he was never presented with a search warrant. Was that your testimony? So he was never presented with a search warrant. So if you're tying it to a time of him being made aware of the search warrant, he was never made aware of a search warrant.
Okay, then let me, okay, having him testifying to that, was the search delayed 5 hours before they started searching, or did the officers search prior to 5 hours?
But they was already walking around and they brought me back in.
Okay. And I believe that that Officer Viverito testified that there were, that she was in the apartment and had walked around and was being shown different things, i.e. where guns had been hidden. And she saw,
Leading, Your Honor.
okay. It's something she testified to. Let me just ask you this. Without an officer searching, would they have been able to see the gun that was hidden under, I think she said, a chest or hidden under some shelves?
You asked me, would they be able to see it?
Without them having to search for it, would they have seen it with just their plain eyes, this gun?
No, ma'am.
Or these guns? Okay. And you understood the question.
Yes, ma'am.
In other words, would they have had to
He understood
search?
it. You don't have to repeat it.
Okay.
Let's not repeat something that was understood and testified to.
Okay.
New question.
It's just that I was talking while he was talking, so I wanted it crystal clear.
Well, we don't need to re-ask. I heard the
I
question
understand.
and the answer.
I understand. And there was somebody else that lived at the apartment with you.
Yes, ma'am.
Was it your girlfriend, Miss Reed?
Yes, ma'am.
When she got to the apartment, you had already been taken away. Is that, or were you there when she got there?
No, I wasn't there.
Okay. Judge, regarding the marijuana or any of the firearms that were located, because and Judge,
Let's do testimony. I mean, I don't, do you have any more questions of this? Yeah. Do you have any more questions?
Question. My question to you is,
To me or to your client?
to Mr. Gunn.
Okay.
Were credit cards in plain view without a search of the apartment?
No, ma'am.
Marijuana in plain view without a search of the apartment? Or guns
Yes, ma'am.
in plain?
The marijuana was in plain view.
I can't.
He said the marijuana was in plain view. That was
Okay.
the end of what he said.
All right. Do you know whether or not Officer Viverito was able to see this after anything in plain view, after the initial set of officers came in and searched?
What's the question you said? Was she able to see it?
Was any of this, was Officer Viverito able to see any of these things when she came into the apartment?
Yeah, marijuana.
All right. Were you present when they were talking about trying to get a judge to sign a warrant?
No, ma'am.
Okay. That's all I have.
All right. Any cross, Mr. Hiles?
Yes. Mr. Gunn, at this time, when you were arrested on these warrants, you were currently on probation for participation in street gang activity and a robbery reduced from armed robbery. That's correct.
Yes, sir.
Okay. May I interrupt 1 second, Mr. Hiles? I think the robbery was down to a theft.
It was armed robbery reduced to robbery.
I think it was a theft per the indictment. I'll work on that.
Okay.
Could you ask the question again?
Well, Miss Rockwell, I think that's improper. If you want to recross or redirect on that, otherwise you can't testify or impact your client's testimony. So next question on cross, Mr. Hiles.
And Mr. Gunn, you're aware that the warrants that you were being sought to be picked up on alleged that you had been filmed at a funeral for a gang member as to where you were carrying weapons. Are you aware of that?
No, I didn't know at the moment.
Okay. But you would agree that if an officer was going to arrest somebody who has been a known gang member and was on probation for weapons charges, that it would be incumbent upon that officer to ensure that there were no other dangers inside the apartment, correct?
Judge, I'm going to object to that. I don't know that Mr. Gunn is qualified to answer what police procedure would be, so I would object to that.
Sustained. Ask a new question.
Okay. Mr. Gunn, if you were walking into a house where you believe somebody was armed and associated with other armed individuals, you would want to make sure that nobody else in that house was armed as well, correct?
Objection, Judge. That's speculation.
Overruled. You can answer.
What's the question again?
That if you were walking into a house where you knew somebody was potentially armed and associated with other armed members, you would want to make sure that there was nobody armed in the house, correct?
No, sir.
All right. And you were the only person inside the apartment when this arrest was made, correct?
Yes, sir.
Okay.
If there's anything you can do to speed it up, because my battery's about to die. Mr.
Okay. I'll rest on that. I want to get through this hearing. I think I've heard everything I need to hear.
All right. Anything further, Miss Rockwell, with your client?
No, Your Honor.
Okay. You can step now. Any other witness for the defense, Miss Rockwell?
That's all, Judge.
All right. I'm going to keep the evidence open for the state's other photographs, and because we're about to die on our cell phone battery, how about you argue by your closing argument? You can submit by written submission. Is that okay with the state?
That'll be fine. When would you like that due?
You tell me.
Wednesday? Is that too
Okay.
long?
Ms. Rockwell, is that okay by you? For you
Judge,
have your closed by written submission due Wednesday?
Judge, okay, so who's going to go first? I think the state has the burden.
Okay, the state can be due Wednesday. When would you want yours in response?
Could I have the following Monday, Judge, please?
Yes. I think we still have the matter of the 404B. See what you can get in quickly here, Mr. Howells.
Yes, Your Honor. The 404B, I did file under that. But more importantly, I filed under the
I'm sorry, hold on. I've got it charging, but it's not charging apparently. Or if it is charging, it's. We're gonna try another charge. I think maybe now it is.
Oh, I heard it.
So can you click on there for it to accept it?
There's nothing showing requesting acceptance.
Usually, let's try your charger, please.
Hold on, Apple, right?
Thank you. No, I think it's, okay, yes,
Is it charging?
yes.
All right. We'll see. We'll see if this will give us juice. Go ahead, Mr. Howells, on the 404B.
Do you want to go ahead and argue the motions for the motion to suppress, or would you still prefer?
That's what I just allowed you briefing on. The motion to suppress statements, I'll get an order from Ms. Rockwell based on the state's representation. There are no statements. We can put that in order. Ms. Rockwell can draft that. You're both going to brief your closing argument on the motion to suppress evidence after I get your photographic evidence. Your brief on that, your closing argument on that is due Wednesday. That's what we just discussed, Mr. Howes.
I didn't really.
believe.
Yeah, I thought we were both going to be do the same day, but if we're going to use it as an argument, I think I do have a right to defer and go last. So I would ask that I could respond to Ms. Rockwell's argument.
But I
Well,
think the
okay.
state has, go ahead,
Listen
Judge.
to me, listen to me. Mr. Howes, your brief on closing, I want you to do the initial closing and have it due Wednesday. Ms. Rockwell can respond by brief the following Monday, and then I'll give you final word with a final reply argument. When would you like that in, Mr. Howes?
If she's going to do the, I guess if hers is due Monday after mine, the Thursday following that, or Friday following that.
No, let me get it. Let me do it. This little. So I'm looking at a calendar. Today's the 19th. The state's closing brief is due March 24th, Wednesday. Ms. Rockwell's response is then due Monday, March 29th. So after that March 29th date, when do you want the state's reply due? Mr. House?
Can we do Friday, April 2nd?
Yes, Friday, April 2nd for your reply. Does that cover it?
Yes, it does, Your Honor.
Okay. Now are we on to the 404B, 418, et cetera motion? Notice from the state?
I am, Your Honor. Let me pull up my notes real quick.
You can let the other lady know that she can come back in the courtroom now.
I'll send her a text right now.
So you're sending who a text?
Oh, I thought you meant I thought you were talking to me about letting Officer Viverito back.
No.
It's okay. I totally misunderstood who you were talking to. This is a process.
I can totally see how that, I mean, hey, considering how this day has gone thus far, I can understand. So I allowed Ms. Rockwell's other potential witness back in the courtroom is what I was doing. So what's your proffer on the 418, 404B motion, Mr. Howes?
So, Your Honor, my proffer is this, that the robbery for which the defendant is currently on probation for. He pled guilty under 18 SC 157210 to participation in criminal street gang activity. I believe it was a robbery that was reduced from armed robbery. I'm pulling that up right now. But in that robbery, the whole basis of the robbery was this idea of Mr. Gunn being disrespected inside of Club Crucial by the victim. Some comments were made while at the club by the victim in this case, in which Gunn directly responded with an armed robbery as sort of vengeance. And because this is under 418 as well as 404B, it goes directly to the membership of and participation in a criminal street gang. Specifically, it goes to what the expert would testify to as motives for your operation in a criminal street gang, that when one is disrespected, that however slight the comments may be, the response in order to maintain credibility with the gang and maintain credibility on the streets would be oftentimes to respond with some sort of act of violence. And this ties back in to the current case where we're alleging that the defendant was in possession of firearms because, one, he was at a funeral of a well-known gang member during a time where there is a war going on. And that same show of force and flashiness at the funeral of the weapons with other members of the gang is along the same lines as the previous account. And I point out that that would go directly to the involvement in gang activities, how gang activities operate. But 418 is a little broader than 404B. It says in a criminal proceeding in which the accused, in which the person is accused of conducting or participating in criminal street gang activity as defined in 1615-3, this evidence shall be admissible and may be considered for its bearing on any matter to which it is relevant. And I do know that there has to be a 403 analysis. I'll defer to a case called Anglin, Anglin v. State, the site 302 GA 333. But on top of the motives listed in the 404B motion for admissibility, we're also arguing that this is even more relevant under 418, and it is assumed to come in because of the shall be admissible. And it would go directly to explaining why one would be carrying weapons at a funeral, and why one would also have to maintain weapons as being a member of this particular gang.
Is that the only other act that you're seeking in your motion, just that one?
Just that one, Your Honor. It's
right. Ms. Rockwell, let me hear from defense.
First of all, for the record, the plea transcript is not available right now. I was looking for it. The plea was a negotiated plea, but it was an offered plea, and we elocuted it to bring the negotiation, if you will, of the case, that this was not any kind of robbery whatsoever. Mr. Hiles, I sent you a copy of page 1 of the plea where it was dropped down to a theft by taking. The basis of the conflict between the defendant and the alleged victim, who is now deceased judge. The alleged victim was killed, was shot while Mr. Gunn was in jail. So there's not any kind of allegation that there was any involvement of Mr. The alleged victim was in Mr. Gunn's case that he pled in, was a victim of an armed robbery and was shot and killed. And so is not going to be available. So my concern is that the state not just be able to proffer that the theft had anything to do with any type of gang activity. And I don't know if they would be able to go forward with a similar if the victim, Mr. Chirazi Bailey, is not available. So I would just caution the state that they wouldn't just be able to come in and say, oh, he's a gang member and this was a gang incident and the gang incident basis is because of any type of disrespect. So having said that, I don't know if the state would reconsider if they did not have a victim, i.e. Chirazi Bailey, of the theft and the alleged firearm that was never recovered. The facts of the case, there was a text messaging back and forth because Mr. Gunn had not paid Mr. Bailey for some marijuana at any rate. So I would ask the court, before the court rules on that, if the state feels like it's going to be able to go forward without the victim. And I would just ask if the state would have, if that might be better addressed by brief also, Your Honor.
Well,
So how do you propose to present it, Mr. Howes, and then respond otherwise to Ms.?
yeah, Your Honor, I would just ask for a tentative, like a ruling as it is now. There are other witnesses that observed the robbery that was later reduced. I'm certainly understand that he has the right to confront witnesses at trial, and I wouldn't attempt to bring that in if I thought that was going to be violated. So I just need to interview other witnesses. That was actually the first. We talked to Mr. Bailey long ago, but that was the first I've known about him being killed.
And Judge, I may have mentioned that to ADA Adrian Love.
Well, that's regardless. I will give the state an opportunity. I'm not going to exclude it if there's other potential witnesses. Certainly, it has to be through proper evidence, but that's not going to be a reason for me not to allow the state that opportunity. So any other argument, Ms. Rockwell?
That's all, Judge. I just because of the Sixth Amendment and the right to confront the alleged victim, it was, and when Mr. Hiles gets a copy of the plea transcript, it was very much detailed. So anyway, I appreciate the state's position that the state wouldn't just go forward with it without having a witness. So I think we could stand down on that, Judge. And if the state is able to present it with witnesses, I would concede that that would be possible, but but the state would have to show that there was gang activity, and this was that all this was because he was participating in a gang, etc. Not just some disrespect over whether or not somebody was a real artist versus just riding on some other artist's coattails. For that reason, I had Miss Abercrombie here to discuss Duct Tape Entertainment versus whether or not Duct Tape was a record label or a gang. So we don't have to go there, Judge, until the state, I think, can present a case with somebody other than a deceased victim. That may conclude our motions.
Okay, I was just trying to see if I could pull up the on Odyssey the sentence sheet.
My connection's twirling right now. I've tried to.
Mr. Hiles, I sent you a text.
Yeah, it's theft by taking. I was able to pull it up.
Okay.
Count 1 was participation in criminal street gang activity, guilty under Alford. Count 2, armed robbery, guilty to lesser included offense of theft by taking. Okay. And then count 3, aggravated assault with intent to rob, guilty under Alford. And then count 4, possession of firearm during commission of a felony, guilty under Alford.
Right. Okay.
So it was reduced to theft by taking.
And that was a straight up guilty plea, Judge. Some unpaid for marijuana. So.
And there.
All right. Anything else for the state?
Your Honor, I also I just want to bring this to the court's attention that had filed a probation revocation under case number 18 SC 157210. I filed that back in September. It's a Dunaway case, but I don't might need to wait on some of the rulings from this hearing as far as scheduling goes with that, but I just want to
So
bring.
no, I mean, if it's based on this new case is assigned to me, then I handle the probation revocation.
Okay. Yeah.
There is
So
a,
if we'd have known that before today, we could have heard that. How much time is remaining on that?
It's on the final disposition, it states back to Dunaway for
Okay.
revocations.
All right. If it's a back to Dunaway, then it does go back to him.
For your question, it's 7 years probated, 5 years suspended is what's left.
Is what's left. Okay. Well, if it's a back to Dunaway, then it needs to be heard by Judge Dunaway.
And I filed it in front of and served him and his case manager as well. So.
All right. Well, then that's what you need to do there, and just communicate with their office if you want to try to get it on a calendar or something.
All right.
All right. So, Mr. Hiles, if you'll prepare an order in line with the ruling that the 418, 404B evidence will be admissible, assuming that, and you're able to present it by admissible evidence. Of course, the defense never has, at the end of this type of ruling, any kind of waiver of that argument. You have to be able to present it by proper evidence. When can you get that proposed order to the court?
I can get it to you. I'll get it to you Monday.
All right, Monday is fine. And Ms. Rockwell, do you want an order just for clarity on the record that there's not going to be the admission of any statement by the defendant? If so, if you could prepare that and get it to me by Monday as well, could you do that?
okay, I'll do that, Judge.
All right.
Or
And
I could withdraw my motion to suppress evidence. I could also just do a notice of withdrawal of my motion to suppress a statement, since there are no statements.
that's whatever your preference is.
Okay.
Different folks want different things.
That's
but I think
faster, Judge.
Okay.
I can just
Okay.
put notice to withdraw. That'll be there by Monday.
Yeah, 1-page notice of withdrawal and you're good.
Based on the state's
get that filed
assertion.
by
that-
Monday.
Thank you, Judge.
So if you can get that filed by Monday, I think that'd be good. And I'll get your briefs on the motion to suppress evidence and rule as soon as I can. And we will admit the photographs if there's not an objection, but y'all handle that by email. And I'll rule on whether to admit or not the 2 photographs. Anything else that's outstanding, Mr. Hiles?
No, I just photographs and your orders, and I'll get both of those over to you by. I'll get the order by Monday, and what date?
And then the closing, you got your closing argument briefing schedule as well, right?
And what's the schedule for that again? My pen is.
Oh, Mr. Hiles.
I think it's Wednesday.
Wednesday,
Monday.
the 24th for Mr. Hiles' closing argument brief. The defense, Ms. Rockwell's response is due the following Monday, March 29th. And then the state gets to reply by that Friday, April 2nd. So March 24th, March 29th, April 2nd. That's what I have.
All right, thank you very
Judge.
much.
Thank
All
you
right.
so much, Mr. Hiles.
I'll call you soon, Renee.
Thank
Okay.
you all for your patience.
Thank you, Mr. Gunn.
and He can hear you. Do you hear her? All right. We're excusing him now. Taking him
Thank you,
back.
Judge.
Thank you all. You can all sign off. Thanks a lot.
All
Have
right.
a good weekend.
May I be excused? Thanks.
Yes, please.